Good morning, class. Settle down. Let's settle down. Welcome to today's crucial explainer lecture. We are focusing squarely on the Transfer of Property Act 1882. Specifically, we're going to dissect question 27 for your upcoming KSLU semester examinations, the core concepts of the universal Donee and onerous gifts. Now, pay very close attention to me, because this isn't just about understanding the bare act, it's about knowing exactly how to present it to your examiner to secure maximum marks.
This right here is the exact structural blueprint I expect to see on your answer scripts. 1. Introduction to Special Gifts. 2. Onerous Gifts, Section 127. 3. Universal Donee, Section 128. 4. Onerous versus Universal Donee. 5. Landmark Case Law Analysis. And 6. Conclusion and Exam Strategy. Mark my words, KSLU evaluators, actively look for this precise, sequential structure in a 16-mark answer.
Heading number 1, Introduction to Special Gifts. Let's establish our foundational jurisprudence.
Read this carefully. The Transfer of Property Act, 1882, recognizes special gifts where liabilities accompany benefits. Under this umbrella, we have onerous gifts governed by Section 127 and the universal Donee governed by Section 128. You absolutely must use these statutory sections as your opening paragraph. The TPA 1882 doesn't merely hand out free benefits, it meticulously accounts for statutory burdens. You see, when a property is transferred, it doesn't just float in a vacuum. It often carries the heavy weight of debts or obligations. Opening your answer like this instantly signals to the evaluator that you grasp the dual nature of property transfers.
Moving on, write this heading in capital letters on your sheet. Onerous Gifts, Section 127.
Let's define it. Onerous gift. A gift burdened with obligations or liabilities. Let's pause right here to ensure total conceptual clarity. The word onerous literally means legally burdensome or requiring heavy, oppressive obligations. This is a gift that comes with severe strings attached. Sure, you're receiving an asset, but you're also inheriting a legally binding headache alongside it.
He who accepts the benefit must also bear the burden. Listen to me, I want you to take your pen and explicitly underline this maxim on your answer script. The very second the evaluator opens your paper, this underlined quote must capture their attention. This underlying legal principle is deeply rooted in the doctrine of election and common sense equity. You simply cannot cherry-pick the profitable parts of a transaction and conveniently discard the liabilities.
Point 1. Gift consists of both benefit and burden. Point 2. Donee must accept the whole gift. Point 3. Cannot partially accept and reject. You need to list these out exactly as they are numbered here. The rule against partial acceptance is absolute in Indian law. Why? Because the law aggressively prevents unjust enrichment. If a donor bundles a highly profitable estate with a heavily mortgaged, debt-ridden property into a single gift, the donee is forced into a binary choice. You take the whole shebang or you take absolutely nothing.
But wait, there's an exception. If the donee is not competent to contract, meaning a minor, they may accept the benefit and can reject the burden later on attaining majority. Now, bringing up this exception, this is what separates an average run-of-the-mill answer from a top-tier score. Mentioning this proves you actually understand statutory protections. A minor lacks legal capacity to contract under the Indian Contract Act. Therefore, the law naturally shields them. They get to enjoy the benefit right now, and the moment they turn 18, they exercise their sovereign right to legally reject the attached burden.
Consider this exact illustration. A gives two properties to B, one profitable, one with heavy debt. B must accept both or reject both. Using illustrations is non-negotiable. It proves your conceptual mastery to the examiner. It shows you don't just memorize bare acts, but you can apply them to real-world scenarios. In this specific illustration, B cannot just turn around and say, well, I'll take the profitable land and leave the debt-ridden property to A. Absolutely not. Section 127 strictly prohibits this kind of legal gymnastics.
Leave a clear line break on your page and write down Heading 3, Universal Donee, Section 128.
The definition reads, universal donee, a person who receives all the property of the donor. Pay very close attention to that little word, all. This strict clarification is exactly what distinguishes Section 128 from standard gifts. We are not talking about a fraction. We are not talking about half of the estate. It is the absolute entirety of the donor's movable and immovable assets. Let's read the features. Liable to pay all debts and liabilities of the donor. Liability limited to the value of property received. Gift of entire property. Donee steps into position of donor.
Liability extends to existing debts. By taking the entire estate class, the donee is literally stepping into the donor's shoes. But crucially, and I want you to highlight this ceiling of liability for yourselves, the donee isn't going to be personally bankrupted by this. Their liability to the donor's creditors is strictly capped at the total value of the property they received.
Here is the exact illustration you must deploy in your exam. Illustration: A gifts all his property to B. A has debts of 2 lakhs. B must pay debts to the extent of property received. Let's do the simple mathematics of the liability shift here. If the entire property B receives is worth 3 lakhs, B pays the 2 lakh debt in full. Simple. But if the property is only worth 1 lakh, B pays that 1 lakh to the creditors, and B's legal liability is completely discharged. The remaining 1 lakh debt does not mysteriously attach to B's personal, pre-existing assets.
Heading 4. Onerous versus universal donee. Mark this as the most critical comparative section for any 10-mark question.
Let's compare the two across these exact bases. Nature: onerous gift is a gift with a burden. Universal donee is a gift to the entire property. Liability: for onerous, it's specific to the gifted property itself. For universal, it encompasses all debts of the donor. Choice: for onerous, you can accept or reject the whole gift. For universal, there's absolutely no escape from liability to the extent of the property. Scope: onerous is limited, universal is wider. I am instructing you right now, take a ruler and draw this exact matrix in your answer script. Do not write clunky paragraphs where a clean table will do. This visual contrast effortlessly secures maximum marks from any evaluator.
Heading 5. Landmark case law analysis. Remember, class, an answer quoting statutory law without supporting case law is fundamentally incomplete.
The first mandatory case is Gomti by v. Matu law. State this case name clearly and deliberately in your minds.
Facts and ratio decidendi. A gift once accepted binds the donee with conditions. Relevance: it mandates strict adherence to Section 127 obligations. Exam strategy: write this case law in a separate boxed format. Let's explicitly detail this so you understand the why. The brief factual background of this dispute centers on a donee who attempted to accept a property transfer while simultaneously, and rather cleverly, trying to shed the attached burdensome conditions. The final ratio decidendi, the binding verdict of the court, was absolute. A gift once accepted binds the donee with all conditions. You cannot dissect the transaction. The absolute relevance of this case to Section 127 is that it perfectly codifies the equity maxim we discussed earlier. It legally cements the principle that you bear the burden if you take the benefit. On your paper, draw a strict, neat box around this case name.
Now for our second landmark case, Renakuntla Rajama v. K. Sarvanama. Pronounce it authoritatively and commit it to memory right now.
Facts and ratio decidendi emphasize the validity and effect of gift acceptance. Relevance dictates the legal threshold for when liability shifts to the universal donee. Exam strategy: underline this case name in black ink. Let's unpack this concept of validity based on the text. The factual matrix here involved challenges to whether a gift was legally complete and fully accepted, which is what actually triggers the transfer of rights and liabilities. The Supreme Court's final verdict emphasized the absolute validity and the immediate effect of gift acceptance. The absolute relevance here is that it dictates the exact legal threshold. The very second the universal donee validly accepts that entire estate, the liability for the donor's debts instantly shifts to them under Section 128. I am giving you a strict directive here. Underline this case name in thick black ink on your KSLU answer script.
Finally, Heading 6, Conclusion and Exam Strategy. Let's sum this up. Conclusion: onerous gifts ensure benefits are not enjoyed without burdens. Universal donee imposes broader responsibility for the donor's liabilities. Both promote fairness and equity in gift transactions. Do you see what we're doing here? Wrapping up an answer with the overarching themes of fairness and equity elevates your entire script. It proves deep jurisprudential understanding to the evaluator. It shows you understand not just the dry mechanics of Sections 127 and 128, but the very philosophical intent behind the Transfer of Property Act itself. I leave you with this final academic question to ponder today. If equity and fairness are the ultimate goals of property transfer, how will you structure these precise sections and case laws to prove your true mastery to the examiner? Remember the strict structural discipline required to conquer your KSLU exams. Present your headings clearly, quote the maxims, deploy those practical illustrations, box your case laws, and always conclude with jurisprudential equity. All right, class dismissed. Go and prepare diligently.